Welcome to today's program titled Navigating Cultural Flashpoints in the Workplace from a Legal Perspective. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for the webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Sam Schwartz-Fenwick. Sam, please go ahead.
Thanks so much, Kate, and good afternoon, everyone. My name is Sam Schwartz-Fenwick, and I'm a partner in the Chicago office of Seyfarth Shaw in the Labor and Employment Group, and I'm honored today to be joined by my partner, Don Soloway, who is a L&E partner in our Boston office. And together, we co-lead Seyfarth's Cultural Flashpoints team. Now, before we dive in, I just want to say a few words about our team, because it really came about organically since 2020, as a number of us who are both counselors and litigators started just sharing around the water cooler that we were getting types of questions we hadn't previously received that were really revealing a level of acrimony in the workplace that was really hitherto unknown to all of us. So we decided that this was really an opportunity for us to try to help employers navigate these spaces to make sure that the focus of their workplace remained on doing productive work, and that these types of flashpoints, we call them, but really where different employees have different views, that's not able to sidetrack the entire workplace. So our group, which has about 30 members, what we do is, we provide trainings and develop policies that help employers lower the temperature in their workplace. We also engage and advise clients on sensitive employment decisions where they're nervous about both the internal and external consequences of any decision they make. And of course, if litigation occurs, we provide sound and aggressive litigation defense, often in the face of very high media attention. So if you could go to the next slide. So here's our agenda for today. So we want to drill down on what we mean when we talk about cultural flashpoints, and then talk about the Seyfarth way for helping clients look at these issues from a legal perspective to help them navigate what is the best solution for them and what solution or potential solutions make the most sense. Then we're going to talk generally about some best practices and policies, both to navigate these issues to lower the temperature, but also to mitigate legal risk, knowing that despite best intentions, sometimes lawsuits are inevitable, and all you can do is make sure you have the best records in hand to defend yourself. And then Dawn is going to end us with how we can help, and just reiterating kind of what our team does and the soup to nuts approach we take in this area. So Pete, if you could advance 2 slides. So when we talk about cultural flashpoints, really what we're talking about is the polarized nature of the United States, in that the workplace is not immune from that. That the arguments you see happening on the news or on social media, those are not checked at the door anymore. They're really brought right in to the workplace. And people's are ever more confident in bringing their full selves to work. I think that's really been a mantra over the past decade or two, that the best workplaces allow people to bring their full selves to work. And these cultural flashpoint issues are part and parcel of that. There's nothing inherently problematic about that. It more just takes some nuance and strategies so that when issues bubble up, we don't go to our kind of innate place of burying our head in the sand, taking deep breaths, saying, make it go away. And instead, we have tools for engaging head on, both to lower the temperature and, if not, figure out what our core values are so that we're prepared to defend them if we need to. Just some examples of how these issues arise. I've been doing LGBT related diversity and inclusion training for over 15 years. And it wasn't until 2 years ago that for the first time I received a real backlash in one of these trainings to the topics on which I was presenting. And they were in different trainings, but in some, there was a feeling among members of certain minorities of color that the LGBT community was taking up too much space, and that the needs of their group were not being given the same weight. At the same time, there were employees who felt their religious beliefs were being marginalized or ignored by this LGBT rights view of inclusion. And so what you had were all these different groups feeling that their identities were under threat and being challenged. And so in a situation like that, that's really volatile, that's an example of a flashpoint, that an employer is trying to do the right thing. They're trying to embrace inclusion and they get a big backlash. So that's just one example about what we mean. Let's go to the next slide. So as our heading, Dawn and I spent, an inordinate amount of time and talked to a lot of people about how should we phrase this? Because we wanted to make clear that our lane at Seyfarth, we're lawyers. I think some of these flashpoint issues, require you to talk to a publicist. You might need to speak with consultants depending on what the issues are. What our lane is to say, what is your goal? If you don't know what your goal is, it's to help you figure out, well, who can you talk to figure out what you want your business objective to be? And once we have that, then we can tell you what the various legal pathways are. And what we found is by taking, that helps because it takes some of the tension from the room. Because the first step isn't, oh my God, we have this intractable issue, we need a perfect solution, to here are the various legal options we can pick. Any of these are legally permissible. Now talk to your other stakeholders to figure out what makes the most business sense. We think that approach, when we've employed it, it's really helped empower both HR and legal to lead these conversations and really to get results where the initial response to these hot button issues is people don't, they're kind of frozen by indecision over making the wrong choice. And so speaking with Seyfarth, really realizing you have multiple options available to you, it really opens up pathways for conversation. So let's go to the next slide. So just as a potential trigger warning, we are in this slide going to be talking, at least mentioning, a number of hot button issues. And we want to make clear that in doing that, we're just saying the reality of the workplace. We're not putting our hand on the scale of saying who has the right view, who doesn't. That's not our job. We're neutral legal advisors, and that's the same position we take when we're talking to our clients about this. The reality of these issues is there's rarely, if ever, one right answer or one right option. As long as you're doing, you know, what you view as a legally safe option, maybe there's some legal risk, but it's one you're comfortable with, then that's an option you should be able to get behind. And our job at Seyfarth is really just to present you with the various options based on your business goals. Let's go to the next slide. So here are some examples of flashpoints. And it's really important to realize what a sea change this is in the workplace, that we're even talking about these issues. I think even if you went back 20 years ago, kind of the cultural ethos was, I'm going to punch out at 5 o'clock and I'm going to keep my head down until then. And what we've really seen, though, is a change where that is not the reality now. The issues that people perseverate on before 9 and after 5, guess what? They're talking about those during the day also. They're increasingly placing demands on their employers to take a position. We saw these expectations rise after George Floyd's murder in 2020, when a number of companies made express statements in support of Black Lives Matter. That really raised expectations that whenever other issues would come up, the company would say something. We saw this in COVID, where Dawn can talk about this. There was an explosion of people bringing their religious beliefs front and center into the workplace to say, I'm not getting a shot. As just one example. And of course, the impact of the Me Too movement has been a sea change in really every facet of life. But so these are just some examples of where we've seen tension potentially between different groups of employees or between existing corporate policy and the views of certain individuals. If we can go to the next slide. So Seyfarth, this is just the headers. We can move on. Sorry about that. So when we're talking about the Seyfarth approach, and this is not limited to cultural flashpoints, this is really our North Star principle in all discussions with clients, but is that whenever you have a client question, before we provide our legal advice, we need to hear the voice of the client. That means figuring out what the client wants to happen. And if they don't know, help them brainstorm to try to figure out what they may want. So in this context, sometimes clients have a real view, well, maybe what they want to do. We want to enact this policy and we want to keep our name off the front page of the New York Times when we do it. How do we do that? Right? That's an example. So we can talk them through the legal issues and provide recommendations for other subject matter experts who can help them with some of the publicity minimization. But a lot of times the clients don't necessarily know, or the person who's our contact isn't the right stakeholder. So it's helping them identify who are the proper stakeholders who could make these decisions. You can also talk about, what is motivating this? When you think about what prompted this discussion, how does that just on a facial basis mesh with your corporate values? How does it mesh with your business needs? Are these demands coming internally or externally? Who's bringing them? That can really help bound the discussion. And then you can, at a high level, even if, what we can do, even if we don't know where you want to go, we can say, here are the potential paths you can legally take as you start having these discussions. Then what we found as we move to the next slide, a really good next step is, the person we've spoken to, or we're happy to join in these discussions too, but they're armed with the tools they need to lead this discussion internally. They can go with confidence and say, here are potential options. Here are the potential pathways we can go. Let's do a risk benefit analysis of each and every one of these. Let's figure out, speaking with HR, DE&I, labor relations if you're a unionized workplace. Let's talk with PR. Let's talk with all these groups about the risk benefits of each, understanding that these are legal choices. So we found that that next tier of empowering the client to lead these discussions can be really helpful. Let's go to the next slide. Part of our voice of the client discussion is, let's take a deep breath. Let's think about what this issue is, and let's think about whether it makes sense to issue a statement at all. Let's talk about the pros and the cons of saying anything. Now, sometimes you have to, right? Often there will be an issue where, let's say an employee says, because of my religious beliefs, I'm not going to this diversity, equity, and inclusion training. Okay, you need to have an answer to that, either okay or not okay. But if someone's saying, what do we think about, a one China policy? Maybe you want to wade into that. Maybe you don't do any business in China and Taiwan, so it's totally irrelevant. So you want to think about who is the person bringing this up? How does this mesh with your business needs? And have that in mind. I suggest making a list even, like on the left are pros, on the right are cons, and then using that and adding to it in terms of your discussions with legal and HR and any other stakeholders about whether it makes sense to even issue any statement. Something that we've seen is that a lot of companies are just making have a policy that they've written down that says, we're not wading into these unless it really impacts our direct business. We don't want to be in the position of having to take a stand on every social issue, so we're just not going to speak unless it directly impacts our business. That's certainly a fair approach. I think other clients, though, are of the viewpoint that the demographics that buy their products and their employees require them to speak out on a lot of issues. So again, there's not a right or wrong. It's just something to think about. Let's flip to the next slide. All right, so now I am excited for you all to get to hear the brilliant words of wisdom of Dawn.
Thanks, Sam. So we really want this webinar to be practical, and we know that employers are really interested in what are some of the common flashpoints that we're seeing in our clients' workplaces all over the country. And then later on in the presentation, we'll dive into some best practices that we recommend when dealing with these flashpoints. Although, as Sam said, there's really no one-size-fits-all solution to these issues. They're very fact-specific, very sensitive, and so the approach is always going to be different for every different workplace. Can we have the next slide, please? So Sam touched on this briefly, but religious issues are one of the real flashpoints around the country. And we saw this particularly in the vaccine disputes of 2021, where a lot of employers had mandatory vaccination policies and many employees objected to getting vaccinated on religious or medical grounds. We also have seen it this past fall in the Israel-Hamas war and some of the religious issues that sprang from that. And so wanted to just spend a quick minute talking about the basic law in this space. So there's of course a potential claim for religious discrimination, treating someone differently because of their religion, but there's also the law relating to religious accommodations. And that law has changed significantly in the last year because SCOTUS Supreme Court issued a unanimous ruling in the summer of 2023 in the Groff versus DeJoy case that changed the standard for religious accommodations. So in a nutshell, if an employee has a sincere religious belief that conflicts with some sort of workplace rule or requirement, the employer has to engage in an interactive process to determine if it can provide a reasonable accommodation without undue hardship. And the Supreme Court decision in 2023 changed that standard for undue hardship. So that standard is now that the employer has to be able to show substantial increased costs in relation to the conduct of the particular business. And so that's kind of the legal framework. Can we have the next slide, please? But what we have seen is a huge increase in the number of religious accommodation requests. And I think that's for a couple different reasons. One is that because of the vaccine era and the fact that so many people were requesting exemptions, employees are now aware that there is such a thing as a religious accommodation. And then, of course, the Supreme Court case also brought a lot more attention to this space. And so we're seeing more requests can we have the first bullet there? Kate, thank you. More requests for religious accommodation. And one thing that's been an interesting development is they appear in many cases more professionalized than employers used to see. So they may be assisted by outside groups, political or religious groups that are very much in this space, interested in making new law in this space. And they may also be ghostwritten by counsel. And so that's really something that we never saw before 2021, and that employers should be on the lookout for. We also, as I said, there are still requests for exemption from the COVID vaccination requirements. That's the next bullet. And, there are some employers who have changed their vaccination policies over the last couple of years as the pandemic has changed. But many clients still have vaccination policies, mandatory vaccination policies, particularly in the healthcare space. And so we continue to see requests for exemption from those policies. In the next bullet, we also see a lot of requests for prayer space or prayer rooms. So historically, we've always seen requests for prayer breaks, particularly among Muslim employees, because of the prayer requirements of that religion. But what we are seeing is more requests across multiple religions. So it might be Christian employees, Muslim, Jewish, people who are looking for not just a prayer break, but an actual dedicated space in which to pray, or even a dedicated room in which to pray. And so that's a relatively new development. And the number one question we get is, do I have to do that? Do we have to provide that? And that's going to depend a lot on the particular employer. For example, a tiny footprint office is going to be very different from a gigantic office building or warehouse. And, as to what is a reasonable accommodation and what constitutes an undue hardship. But we've developed some best practices and considerations for prayer space and prayer rooms in response to this trend. Next slide, next bullet, please. As Sam alluded to, we are increasingly seeing requests primarily from employees who identify as Christian or Catholic to be exempt from various policies. So diversity training, Pride Month, using their coworkers' preferred pronouns. And this is, as Sam said, something that is pretty new for those of us who practice in this space. These are often challenging, it kind of goes without saying, because you have conflicts between groups of employees and between protected classifications. And so it's something that has to be handled very delicately. I think one important note here is that a request for a religious exemption from something like a diversity training or Pride Month activity should be handled like a request for religious accommodation. I think it can sometimes be tempting for some supervisors or employers, depending on their points of view on these issues, to sort of dismiss such a request, but it is a request for religious accommodation and needs to be treated as one. meaning that there needs to be an interactive process and a deliberate decision about what is a reasonable accommodation and what is an undue hardship. And it's also important to remember that, you know, in terms of what is a reasonable accommodation or an undue hardship, that there are many reasons why employers may want to very vigorously defend their diversity training and Pride Month activities and pronoun policies. And those are, you know, include attracting and retaining diverse talent, important company values around DE&I, and even compliance with various laws, for example, you know, with respect to training. And so there may well be grounds to deny some of these requests on the grounds of undue hardship, but it's something that needs to be handled delicately. The next bullet is we are seeing more employers getting requests for religious affinity or resource groups. And that's also a relatively recent development. I think, you know, many employers do have affinity groups for various protected classes, but increasingly we're seeing requests for religious groups. And there, I think, you know, there are multiple options available. Some employers decline to wade into that area at all and say, no, we're just not offering religious ERGs. Some will allow groups that are focused on specific religions, and some will allow interfaith groups that are focused on kind of general religious inclusion at the company. There, it's really important to stay true to the basic tenets of the employee resource group framework. So what are the business objectives? What is the underlying DE&I strategy for the company? And always to remember that the establishment of one of these groups never sets aside company policies about harassment, discrimination, accommodation. And so really it shouldn't be different for a religious group versus other groups in terms of, you know, making sure that any group request is following the general policy and guidelines for some groups. We've also seen some employers who don't necessarily want to wade into the space of religious ERGs, who are allowing more informal groups of employees to meet around religious identity. And so that's another option that some clients are taking. In the next bullet, we are seeing more employees who are requesting for the company to bring in outside trainers. So as an example, ADL does a form of training about anti-Semitism, and that's something that employees have been requesting, particularly since October 7th. And, you know, there, I think, you know, we can help employers think through those decisions. You know, obviously those are stemming from employees' genuine desire for sort of inclusivity and education. But it's really important to think carefully about bringing in outside trainers who have a very specific viewpoint, even if those are otherwise very reputable groups, because we want to make sure that training is compliant and neutral, and also don't want to get into kind of an arms race of various groups wanting to bring in, you know, outside trainers with different viewpoints. Next slide, please. So beyond religion, there are a lot of different ways that Flashpoint topics come up at work. And this is just a small sampling of some of the client questions that we have had, you know, discussions with the client about employees discussing these kinds of issues. So January 6th, police misconduct, Confederate statue removal, some of the public trials, the Eugene trial and Carroll trial and other high profile cases, abortion rights, religious issues, and LGBTQ issues. And, you know, we have a list there of some of the ways that these issues have arisen for our clients. So it might be a one-on-one conversation with employees. I had a recent example of this where a white manager was speaking with a Black employee and kind of opining that, you know, in his point of view, race relations are, you know, kind of overblown, and we've kind of moved past racism at this point. And you can imagine that that did not feel comfortable to the employee who is speaking one-on-one with a supervisor. Obviously, there's a power differential there. The employee didn't feel comfortable speaking up to the manager and went to HR to complain about it. And so that's an example of how, some of these conversations about kind of polarizing topics that have really nothing to do with the work that the manager and supervisor are doing can kind of come into the workplace and require some intervention. We have seen offsites and travel always seem to be an opportunity for people to talk about things that are a little more personal than they might otherwise talk about at the office. And so that's been an area of, where we've gotten a lot of questions. Zoom backgrounds. So we've seen, had clients consulting with us about employees who were, using Zoom backgrounds to make political messages or even to alter the company's background to make it look like the company was supporting a particular political point of view. Displays in the office. So, somebody wants to bring in their MAGA mug or poster or, something else that has political or kind of sensitive Flashpoint kind of content. And that can obviously create issues. Attire, hats, pins, flags. I think we've seen almost every variation on those questions. And then outside speakers at events. So, people who kind of come in to the company to speak about a particular topic, but, once they have the floor, kind of wade into topics that are more sensitive. And so these are the kinds of ways that some of these questions come up, and some of the issues that we've been helping clients with. Next slide, please. And Sam, I think you're going to talk about off-duty conduct.
Yes. So thanks, Don. So one of the ways, and I think that off-duty and on-duty, it's getting increasingly blurred, especially as we have a lot of people working at home, and as certain devices like Slack and Jabber seem pretty similar to, in their casual nature, to Facebook and the site formerly known as Twitter. And so I think that the employees are using, both while on work time and after work, are using these tools. And so a question that's increasingly presented is, what role, if any, can an employer take in terminating an employee based on their off-duty conduct? I think outside of the computer and into the real world, we've talked to a number of employers about employees who've been identified online as ripping down posters of hostages after October 7th, as an example. And there's lots of doxing campaigns where, employers' LinkedIns are being flooded with information regarding employees who've done this. So what are some, kind of outer bound frameworks to think of? One is the First Amendment. That's often going to be batted around, where employees will say, I have the First Amendment right to say what I want to say. That doesn't apply. The First Amendment doesn't give you protection if you work for a private employer. If you work for the government, you do have First Amendment rights. Your First Amendment rights, though, those aren't really relevant at work if you're in the private sector. Another law is the National Labor Relations Act. Even if you're not in a union, you can potentially argue that certain statements you made are protected in concerted activity and thus are protected by the act. The National Labor Relations Board has taken an expansive view of protected and concerted activity to extend to social issues, such as wearing a Black Lives Matter mask, for instance. We've had clients call and say that they have employees advocating for changing certain trans inclusive policies to be anti-trans. That issue has not been presented to the National Labor Relations Board, but it's possible to think they might consider that to be concerted activity. That doesn't necessarily say that's the end all and be all, but it's a factor that employers need to think about. They also need to think about whether they are operating in a jurisdiction that has a law in place on when it's permissible for employers to analyze off-duty conduct. It might be illegal in your jurisdiction, so you definitely want to consider that. But at a minimum, before you take any action when you're presented with these types of issues, it's important to go back to the basics, which is don't make a rash decision. Conduct a full and fair investigation where you learn what actually happened, which might be very different than what's being spread on the internet. And then make a decision that makes sense for your business based on your past practice. Next slide. So DE&I program. So in the current media landscape, DEI is a 3-letter word that's been almost become a 4-letter word along with WOE. There's a lot of misinformation about what DEI is and what it intends to do. There was also, and so, you know, in a nutshell, the purpose of DEI is to reduce the risk of employment discrimination claims and hostile work environment claims, and to create a more level playing field in which all employees have, you know, the experience of all employees is improved. That type of lawful DEI program is important in terms of advancing the goals of recruitment and retention, and it can be helpful. Now, there can also be parts, you know, programs linked to DEI that aren't necessarily lawful. Things that on their face look more like a quota or look like preferential treatment for certain groups. We think that it's really important to get legal advice regarding your DEI program and to engage outside counsel to perform an audit of your DEI programs in light of the current changes to the law, and to make sure that you're staying on the right side of the law as this issue evolves. Next slide. So resume triggers. So resumes have always been a fraught issue where there's a lot of potential for bias. A recent study just this year said that individuals with more stereotypically African-American names are half as likely to receive a callback than individuals with a stereotypically white-sounding name. So there's a lot of historic bias in resumes and a lot of ways to look at things other than someone's objective experience. I think that the Flashpoint dynamic adds a whole nother layer to this. For instance, under people's interests or maybe where they've volunteered, you might see an organization that's been in the news. A lot of this has come up since October 7th in terms of organizations that college students are potentially in, but it would certainly also apply to longstanding people in the workforce. What you want to do in these situations is not necessarily take a uniform approach. You want to avoid stereotyping and overgeneralizations. You want to recognize that, you know, the voice of the leaders of an organization might be different than the voice of their members. And, you know, again, depending on the situation, you might want to give the individual a chance to share their perspective before you just throw out a resume because of a Flashpoint issue you see. It's critical you speak to legal and HR to make sure you're handling it in a non-discriminatory way that's not going to increase legal risk. All right, next slide.
Okay, so we're going to talk I see our time is coming up. There's so much to cover on these topics, and I see a million great questions in the chat as well. But I want to just talk for a moment about how to use policies to take down the temperature. So, some of the best resources in this Flashpoint space are policies, neutral policies. They may be the same policies that you've had for years, but being able to sort of use those as touchstones as we navigate these issues. So, discrimination, when was the company's policy last updated? Is it updated for bathroom and pronoun issues, for example? On the respect policies or basic respect in the workplace, has that been updated, and can it be broadened for some of these issues? Political expression. I saw a question in the chat about, is it a good idea to have a politics in the workplace policy? And the answer is it can be if drafted extremely carefully because of the issues that Sam touched on. Religious accommodation. I think that's actually an area where a lot of companies didn't previously have a policy. They might have had an ADA accommodations policy, but not a religious one. It's a good idea to have a policy in place so that you're guided by it as you get these requests. Social media policy. Is your policy up to date, particularly with respect to state laws, because there's been a lot of change in that area. Next slide, please. We're also finding that clients can do a lot through changing everyday policies where they see flashpoints arising in particular spaces. So I've had a lot of client questions about, fights breaking out on Jabber or Slack, having nothing to do with work, but having to do with whether it's October 7th or other flashpoint issues. And having a good Slack policy about how Slack should be used, making clear that even though it's an informal format, it's still a work communication, perhaps not allowing requests for donations, because that's been an area of conflict. With respect to speaker guidelines, as I said, speakers kind of veering off topic into political statements. Sam and I actually counseled a client and helped them develop outside speaker guidelines that just sort of say you've got to stick to the topic, please avoid distractions. Uniforms is another space where, kind of a basic policy about what is and isn't appropriate work attire can serve you well. And Zoom backgrounds, I saw a question in the chat about, what do you do about political or religious paraphernalia in Zoom backgrounds? We recently helped a client develop a policy that talked about kind of video conferences in general, but as part of it, we talked about either using company-approved Zoom backgrounds, not altering company-approved Zoom backgrounds, and things like that. And so sometimes it's those basic policies that can really go a long way. Next slide, please. So training is your secret weapon. I think if there's ever been a year to invest in training, it is 2024 as we enter this election year. Next slide, please. And, just quickly, who to train the legal folks, the HR folks, the managers who are interacting with people every day. You want to be really careful about hypotheticals. That's been an area where there have been some lawsuits filed recently where the actual hypotheticals that were used in the training were the source of a dispute and a lawsuit. And then how to train, we really recommend live training, ideally in person. The kind of rote online training where you're just pressing forward to try to get through the training isn't really helping anyone. Next slide, please. I'm going to give the CLE code now. So it is SS as in Seyfarth Shaw 8574. So SS 8574. Next slide, please. So in our remaining moments, what you can do in-house right now. First bullet is you can update your policies. You can audit your trainings and make sure that they are kind of up to date for this time period. And consider, as Sam said early in the presentation, an internal Flashpoints team that's going to help you navigate these issues. Next slide, please. And then how we can help. So we can provide policy templates or options. We can review and update your policies. We can provide training for your legal team. Seyfarth at Work, which is a Seyfarth Shaw subsidiary, provides trainings that are specifically updated for these Flashpoints issues. Our Flashpoints team has been working with them to develop that training. We can provide process maps, for example, for religious accommodation, so that you can align on how you're going to have a religious accommodation request go through your company. Is it going to go to HR? When is legal going to get involved? We can provide forms. For example, for religious accommodation requests, we recommend a written form, and we can certainly help you with that. We can help arm your HR folks with talking points for the interactive process with respect to religious accommodations. We can help you think through the voice of the client. One thing that we've done for clients is provide hypotheticals that your internal team can use to sort of develop some internal guidance around how you're going to think about these issues. We can provide benchmarking as to what other companies are doing on some of these more sensitive issues, and develop options for senior leaders to consider. And then finally, we have, of course, specialized expertise in diversity, equity, and inclusion, ERGs, union issues, or really any of these Flashpoints issues, including religious discrimination and accommodation. Wish we could get to all of the questions today, but reach out by email to either Sam or me, and we'd be happy to continue the discussion. Next slide, please. I think we talked about that. And there are our emails. So feel free to send your questions to us, or reach out if you want to continue the conversation. And thank you so much.